should help guide your decisions, and most of the information presented pertains to Los Angeles. However, as far as conservatorship itself goes, that law is statewide. So what's true in Orange County is true in LA or San Francisco. Unfortunately, many of these different counties interpret the laws as they see it, and it may vary from county to county. Also want to share that if you are a conservator in Los Angeles and you have to move to a new county, you can transfer your conservatorship to the other county. Next slide, please. Tips. Okay, so whenever you're talking to someone at the hospital or any agency at all, and you're talking about your loved one and who you are in relationship to them, you don't refer to yourself as the parent, the mother, or the father. You refer to yourself as being the conservator. You want to really impress that you have all these legal rights, and that you have a right to talk to them, and that they have a right to share with you all the information that is available. We suggest that you take the free NAMI to NAMI class. They are online, and they are invaluable for understanding how to best help your family member that's suffering from a mental health condition. We want to keep journals. We want to keep journals on, and we'll explain this as we go along, but you should keep a journal on all the medications so that over a period of time, you can have a record of what seemed to work and what wasn't working based on your observation. And you want to keep journals with people that you want to speak to at a later time. So get involved. You're the conservator, and you just need to really launch this forward. Next slide, please. Yeah.
Okay, the LPS conservatorship, that's the term that's used in the state of California for involuntary mental health treatment. Other states use other terms, but the LPS, when you have a conservatorship, it is only good for California. If they leave the state, it isn't good for other states, but other states might call it a conservatorship, a guardianship. In the state of California, you don't want a guardianship because you would be liable for anything they do or don't do. Your conservatorship, you are not liable for anything. Okay, the LPS conservatorship was named after Latterman Petrus in short, who wrote these laws or these guidelines in 1974, and they were enacted in 1976. It's in, if you want to read about it, it's in the California Welfare Institutions Code 5200. God bless you if you read all that. The laws are over 50 years old, and they really don't reflect the current scientific research in treatment for recovery. Back then, they had very few medications, very few ideas how to help a person with a serious mental illness. That has all changed, and the laws need to reflect the current changes that can help a person with recovery, because people do recovery. And that is our goal in this program, is to give you the tools necessary to help your loved one get their life back as it should be. So that's your goal. Do not settle. If the doctor's saying they're sleeping all day and they go, well, they're doing better. No, they're not. You want your loved one back to where they were. So we're going to talk about what you can do and what you can't do. Next slide, please. The forms for conservatorship. When you got your conservatorship, they should have given you a booklet. It's called Helping Your Loved One, a Family Guide to Conservatorship and Involuntary Treatment. If you don't have it, go on the internet and print it out. It's only maybe 20 pages. It has forms that you would need. It's current information. If they want to get a driver's license, it has a form for that, form for renewals, and Marie's going to guide us through the renewal process. But that's one of the best things you can do, is get that booklet. If you go to court, they usually give it to you there, but they don't always. Next slide. The essence of your conservatorship is to mandate medication. That is the only thing that's not taken off when the person's under the conservatorship. And that is the first process on getting their brain to be able to think clearly and to be able to get their life back. A lot of times people, if they're not on the right chemicals in the brain, they can't think clearly. They're very delusional. And until you get that medication in them, their reasoning ability just isn't there. So that is the essence of your LPS conservatorship, is mandating medication. None of these other programs that they have can they actually mandate medication like you can under the LPS conservatorship. Next slide. The types of conservatorship, now we're referring to LPS conservatorship. There is one that they call probate, but we're not dealing with that. That's for everybody who does not have a serious mental illness. So the LPS conservatorship has a conservatorship of the person. It is the treating doctor, usually at the jail or the hospital, who initiates that conservatorship. And most of the information in this class will pertain to the conservatorship of the person. You also have a conservatorship of the estate. If you need that, which would cover like criminal cases they're dealing with, debts, school loans, anything that they may have to deal with, you can ask the public guardian to help you set up the conservatorship of the estate. If you don't set it up when you get the conservatorship of the person, and 2 months down the road, you go, oh my goodness, look at all these bills they have. You can go back to the court and you can ask for the conservatorship of the estate, but show them what they have. Under the conservatorship of the estate, what I would suggest is you do, creditkarma.com. Run a credit report on them. That's going to give you what debts they owe. And you can pretty much take care of those, pay 10 cents on the dollar, 25 cents on the dollar, or don't pay them at all. If they don't have the money, just notify the people if they don't have the money, and that's the end of that. So school loans, you can pretty much get school loans totally waived. So, but they do have guidelines that you have to follow. So investigate and check those situations out. Next slide. Marie?
Hi, can you guys hear me well?
Sure.
Yes.
Okay, succession of conservatorship. A conservator can be changed from the public guardian to a responsible party anytime during the year. A conservatorship can be changed from the responsible person to the public guardian anytime during the year. The way to do this is you write a letter to Department 103 and request a successorship in the conservatorship. The court, well, be aware that the court will honor the conservatee's wishes, meaning a lot of times we'll get parents or loved one calling us wanting to become successor conservator, meaning to take over from us. But if the conservatee does not agree, a lot of times the court will just follow the conservatee's request and not, process a successorship. Next slide. Who should be conservator? Well, it could be the public guardian. All LPS conservatorships start with the public guardian. From there, it could be transferred to a loved one who's interested and who's willing and able to serve. So the conservator can be the public guardian. The pros are you're able to place the person in a state-approved facility. Another pro, less stress for the family. A negative part to that is less involvement with the recovery process. Another negative is that no control for medication. At PG, we typically go with whatever the treatment team recommends for medication. Next slide.
Okay, Maria, I'm going to add on that. If the public guardian is the conservator, work with them so that you can work with the public guardian because you know your loved one the best. But if you become a pain for them, then they're going to shut you out. So, be respectful. They have a lot of people they're working with. So be respectful of their time and what they're doing.
Should I be the conservator? The pro to becoming a conservator, you get to have direct contact with the doctor or the treatment team. Another pro is that you can reject inappropriate treatment facilities, medication, and treatment places, meaning you guys have more, as a private conservator, you have more leeways to say, no, I don't want my client placed here, or this medication is not working, or you just have more involvement. A negative to being the private conservator is sometimes the conservatee may manipulate you. Another negative is hospital will try to push you around and discharge a patient to facility when not appropriate for level or treatment needed for recovery.
So, Marie, I'm on this slide with you.
Oh, okay, I'm sorry.
No. It's you and I both.
Okay.
So I just wanted to, I'll just ad lib a little bit here, and that is that conservators often don't, private conservators often don't realize the rule of authority that they actually have. If a hospital tries to push you around or they want to discharge the patient, you need to let them know that you have the legal right to know what facility they plan on transferring your loved one to, and B, you have the right to go there to see if it's appropriate for their needs. And I've actually gone so far as to call the hospital out here in Orange County. They pop people out like popcorn, and I just said, "You just violated the law. You did not give me the opportunity to go and look at that facility, and I will tell you that the facility that you transferred my son to is not appropriate. You need to get an ambulance out there today and get him back here today." Well, it took me a few days. They took him back. So stand your ground, be polite. Next slide.
Okay. Liability for the conservator. This is from WIC Code 5358.1. You are not by law liable either civilly or criminally for anything the conservatee may or may not do. You're not financially responsible for the conservatee's debt. But having said that, it wouldn't be wise for you to allow your loved one to get a credit card or open a line of credit while under conservatorship or you co-sign for them. At that point, then there may be some liability. So you have to be wise about your powers and how you use them with your loved one. Next slide.
Wait, just one more. If you give it, they usually withhold the person's right to drive a car. But if you gave them the keys and you told them to go to the store and get some milk and they did and had an accident, you would be liable. So, but if they took the keys without your permission, that's a different story. So you have to be responsible if you're the conservator. Okay, next slide.
I just want to interject here for a second, if I may. Maria, it's not fair to you. We haven't given you a heads up. I think you may have seen, but down in the left corner, usually it'll tell you what page number we're on and the initial of the person presenting.
Oh, okay, I see it.
So cue in on that, and then
Okay.
you'll know if it's your slide or if you're sharing the slide with somebody, and after you're finished reading it, then they'll jump in with you. So we invited you to come today, but we didn't have the good manners of letting you know how it works.
No.
And I do want to say to all the participants, every time we do this, we're switching slides, adding things, and Maurice helps us so much. But we were rushing to get this done at the last minute, and Jim was having trouble with his computer. I did too. So Marie really didn't get to look at which slides she was going to do. We switch them all around so we stay on our toes. Okay, Jim, that was yours.
All right, so it's talking about the rights and responsibilities of the LPS conservator and the power to approve or disapprove all medications, treatment, and placement. As I just referenced to a couple of slides back, you have the right to determine if the discharge placement from the hospital to the board and care or other facility is appropriate for the needs of your loved ones. As Gail pointed out yesterday, if your conservatee is somebody that will do well with loud environments, that's fine. But if they're not, and you go to look at the environment and maybe there's a lot of noise and clatter and clutter and stuff going on that would agitate them, you would need to let somebody know that. And as well, you have the power to go over the medications that the doctor is prescribing. And if you see a medication that you don't feel is appropriate, you actually have the authority to say, a doctor can't prescribe that medication. However, you want to do that with a positive outreach with the doctor. You want to work with the doctor and let the doctor understand that there's a reason why a particular medication doesn't work. For, let's say, Haldol. Haldol, for some people, will cause their tongues to swell and cut off their airways. So you say, doctor, I really appreciate you prescribing these medications. However, you've also included Haldol. And our son, and usually there's records of it someplace, but that particular one. And so you would share why that, whatever that medication is, why that doesn't work well, or maybe you have had better success with another one and ask the doctor if it's possible that he would work with you on that. You don't want to just say, no, I don't like that medication. We're not going to put my son or my daughter on that medication, because that doctor could turn around and go to court and say, Your Honor, I'm a doctor. I've been doing this for 20 years. I know my medications. I understand the patient's needs. And this private conservator is just not even being reasonable with me, and I'm not able to effectively treat my patient. And the court might just yank your conservatorship away from you. So you want to do it the right way. And that's work with your doctor, make positive notes as to why something will or won't work in terms of past performance. Next slide.
If I can add, a good way to work with the doctor is if you tell the doctor, if you say, look, I've been reading about a such and such medication. And what do you think? You're asking the doctor, what do you think if we try a small amount of it? I'll observe what I see and I'll give you the feedback as to, my opinion after he's been on it for just a little bit. Doctors tend to like that, but you're not telling them to give it to the person. You're not telling them not to. You're working as a team, and that's what the doctors like.
Great. Next slide. Well, who wants to go first?
You, Jim.
Okay.
Oh, go ahead. No, go ahead, Maureen.
Well, as the conservator, you have the right to speak directly with the treating doctor. If you have any questions or feel something's not right, go ahead, ask to speak with the treating doctor. Know who your loved one's treatment team is. Start with the social worker, because typically they'll have the social worker or the head nurse typically will have a direct line to the doctors.
Yeah.
Okay. That is the most helpful, working directly with the doctor, but be respectful of their time. If the social worker or the charge nurse can give you all the information you need, then let it go for talking to the doctor. But if there's something you need to speak with the doctor about, by all means, that is your right. And if a facility says, well, in this facility, you don't speak with the doctor, that is not what the law is. So you can apply for SSI, SSDI, Medi-Cal, and Medicare if they don't have it. Because those resources are so valuable into getting them into treatment facilities and getting them the medications that they need. You can also have private insurance. Sometimes it's a little tricky when you have private insurance, because the county has programs where Medi-Cal and Medicare will pay for things. And if you have private insurance, then sometimes somebody in that group will say, well, you can't have private insurance. We can't give it to you. You can. And private insurance can pay for the programs that Medi-Cal and Medicare are paying for. Usually private insurance will be what they take first, and then Medi-Cal and Medicare. But it's going to be a little bit of work, but you can do it. Okay, Jim?
I have a question.
I have no answers.
I want to pick your mind. I'm dealing with the family right now that says, I'll pay for any insurance they want, private insurance, versus Medicare. And I know a lot of people get off of private insurance to get over to Medicare. What are your feelings about the most effective insurance to have in this case?
It depends really about what you're planning to do with the individual. If you're going to put them in like John Henry or some of these other more expensive facilities, private insurance is helpful. If you're putting them in a county facility, your Medi-Cal and Medicare is more helpful. So you have to kind of judge exactly what is your intent, what is it you want to do. I found that a lot of the high-end facilities for treatment are not any more successful than the county facilities. The county tends to have pretty good success. And that's why I tend to like that better. But it really comes down to the individual on what their needs are. Generally speaking, that's what I'm saying. But it comes down to the individual.
Also, if you have a loved one at a boarding care, if you have Medi-Cal, Your loved one can qualify to have an FSP, a full service partnership social worker. This is like an additional social worker in the community, and they bill directly to Medi-Cal.
Okay, great.
Okay.
I mean, that's just one of the bonuses of having Medi-Cal. You qualify for a lot more of the county funded programs.
Right. And they're good. A lot of them are good. Some are not, but if they're not, you contact the supervisor. Be
Correct.
sure on your journal you're writing down names, everybody you speak to, and contact the supervisor. Let them know who you spoke with, what they say. They take care of the problems. It's not necessarily that people are just blowing smoke. They're just reiterating what they've been told. So they make the corrections, and that we've improved DMH an awful lot by families doing that, just reporting and saying, could you please correct this person on what they're thinking or what they're saying? And they do, and the problem's done. Okay, next slide.
Go ahead, Gil.
Okay. The California Welfare and Institutions Code 5358.5 is extremely valuable. This is kind of like your security to keep the person on the right track. The court has said that your loved one is gravely disabled. No one can go in there and say that they are not gravely disabled. The police, another doctor, nobody can. They have to go to court to have that removed, and the judge would remove that. So as a conservator, the law is, and that's the law, that's very important, you have the right to hospitalize your loved one when you deem it's necessary. You don't have to wait for them to decompensate to harm to self or others or become what, quote, the system would consider gravely disabled. It is your responsibility to keep that person on the road to recovery and not to let it start lapsing and going down. So let's say your loved one says, I'm not going to take my medicine anymore. I don't need it. And you try to encourage them, and a week goes by. What you do is right away, you call Marion Brown, her number's down there. This person has to go to the hospital because the hospitals are the only place that can really force the medications. They have to go to the hospital. We have to have them transported to the hospital so that they can get them back on their medications. If you do this once, it probably will be the last time it would ever have to be done. Now, if you wait for a month or two, they're getting sicker and sicker, and then you do it, they're probably going to have like a weekend in the hospital or maybe a week or so. And if you wait really long, guess what? They're going to be in the hospital for a long time and probably go to an IMD. So don't let that time lapse. If your loved one decides they're not going to stay on their medication, give them a little bit of time, work with them the best you can, and then, okay, bingo, off to the hospital you're going. And you call Marion Brown in Los Angeles. She's pretty good. If you have trouble, you call me right away, because we'll get on to people who will help. Because sometimes like the weekend is difficult. And by the way, don't wait for Friday afternoon to call and say, this is what I need. If you've known about it, a few days earlier, because they can get somebody out there to transport your loved one to the hospital. This law is what makes the LPS conservatorship work. Okay? Anybody want to add something, Jim, for Orange County?
I would. Recently here, we've kind of changed our system around in Orange County. And, while this is focusing on LA, it's also, we have a lot of people here from Orange County. And what has happened to myself and another family now of recent is that they can no longer call the CAT team. They have to call OC Links. OC Links then takes your call, and you tell them that your loved one needs to be taken to the hospital. You're the conservator. And they'll say, well, what's going on? And you describe to them the situation. And then somebody at the CAT team says, well, that doesn't qualify for an evaluation, so we're not going to come out. And, it's totally opposite from what Gail has said above here on the Welfare Institution Code. And we do have that right. And I would just say, if that happens to you, don't let your loved one sit there and not get help for 3-4 days or until it gets worse. Call the police department if you're in Orange County, or the sheriff department if you're in South Orange County. And you tell them that you need a police officer to come out to maintain the peace, that you want them to bring an ambulance with them, and that you need to get your loved one into the hospital. One of the other nurses that I've talked to has said, don't even tell them it's a mental illness issue. Just tell them that the person is neurologically challenged and they need to be helped and they need to go to one of the hospitals. But it's upsetting to me that our rights are not being recognized here in Orange County. And I'll speak out and I'll take all the flack they want to throw at me. It's just not right. And I've actually, our family has suffered because they didn't think we met qualifications for them to come out and do an evaluation. Don't put up with that. Next slide.
Okay, and I'd like to just add something on this.
Sure.
Everything we're telling you sounds like, oh, I just have to show them this and show them that. Everything you do, you are going to have to fight for every step of the way. Unfortunately, even though the law is there and it's on your side, you still have to fight for it, but do it pleasantly. Don't yell, don't scream. Go to the supervisors if you have to. Just keep going up the chain of command, or call Jim and I and we'll help you. But, don't think, oh, this is going to go so easily. You're still going to have to struggle, but you can do it. You've got the tools now to be able to open those doors and get what you need. Okay, and just one more thing. I have to say, Jim does what I do in LA, he does in Orange County. And he's an amazing person because he'll be working on a law in something where they're not abiding by the law in Orange County, where in LA they might be abiding by it. So he'll tell LA County or Orange County, the behavioral health, well, in LA, they're doing this, and I do the same. So we share our information back and forth, and that sharing back and forth, if we're doing it in one county, the other county will tend to do it too. So he's been wonderful to work with. All right, next. Oh, this one, California, the law says the court has decreed your loved one is gravely disabled. And remember, the police can't come out and say they're not gravely disabled. Only the judge can change that. Where you take your loved one to the hospital, now they may not want to keep them in the hospital, and that's okay, but give them the medication, because remember, that's the place that they can force it. If they're in an IMD, an Institute for Mental Disease, and they refuse their medications, the IMD cannot force medications, but they can do the 5358.5, send them to the hospital, give them the medications, and then take them back. Okay, next.
CalAble is a program that was started here in California. It's uniquely different. It's almost working like a special needs trust, but it's in a different way. One of the things that is really challenging to families that are dealing with a mental health issue is that the issue arises later in the game here, when their son or their daughter reaches a point that they are then facing, a mental health crisis. They're 18 or they're 25 or somewhere in there. Usually is when it starts. Occasionally it'll start in childhood, but generally it's later in high school or early into college, when you got a lot of stress on them and so forth. And it doesn't occur to families until later in the game that, oh my gosh, we're not going to be here forever. When our loved one, when we're gone, when we pass away, we need to have some money saved up that could be used to help our loved one. If a parent, let's say, has somebody that a child is born developmentally, or they have Down syndrome, they get that like within the first year. It's like, hey, obviously, we're going to have to do every little thing for this individual, and they have some capacity, but they're not going to survive without us. And so they'll start accruing monies and funds, and they'll set up all the kind of structure that's going to be necessary to provide that continued care. And so people that are dealing with mental health issues really fall behind the ball on that. And so they lose a lot of years where they could, accrue monies and leverage monies for the future for their loved ones. CalAble is one of those accounts. There's different ways to accrue money. My wife is into a lot of different issues in that respect. But this is a government account, and what it does is that it can be a savings account, or you can have them actually leverage your funds. And they'll give you 3 choices. You'll let us leverage it the best we can for the most return so that you'll build up your account sooner, or at a low risk or no risk at all, just a savings account. And the monies that are in there can be used without jeopardizing any of the benefits provided to you by Social Security or any government resource that's out there. For an example, let's say that you are needing to supplement the cost of, there's a really excellent boarding care here in Orange County, and their price is way up there. And so some families that can afford it will put their loved one in there, and they will privately pay for the difference in cost. Well, if you're paying for housing for your loved one, then and Social Security then is going to decrease the amount of money they're giving you because you're subsidizing it. And so consequently, if the money's first put into a CalAble account, then you can spend that money for the rent and not jeopardize the government benefits. So it's an interesting thing. It will work in conjunction with a special needs trust. There are costs associated with the bookkeeping, which they don't tell you about, and you may want to ask about if you sign up for that. It's not a whole lot of money, but it is, some monies. And it's really well. Next slide. I think you may have some things listed here, Gail, that they will cover. Yes. Mm-hmm. So you can spend these funds that are in the CalAble account on education, housing, again, for the boarding care or whatever it is, transportation, whether they're riding a bus or get a car. They could actually take their employment funds and put in here. Again, I have to be careful and say employment funds. That doesn't mean that they can work and not be impacted on for their SSI benefits. You need to talk to Social Security about that. But all these different things listed here, buy them a computer, whatever it is that they need, these can all be used and not jeopardize your government subsidies, your SSI or otherwise. Next slide. Yeah.
The LPS conservatorship of the estate, and I started to mention a little bit about that earlier. Run a credit report, find out what your loved one, what debts they owe. If there's money to pay off some of the debts, you don't have to pay the full amount. You can pay 10 cents on the dollar, 25 cents on the dollar. That's very helpful. What we did, we collected everything. I gave a percentage. I knew how much cash we had because we were getting SSI money back, a whole bundle that when it was finally approved. And I did like a ratio. Okay, these people can have this much. I called all the creditors. I said, okay, I'll write you a check today for this amount of money, but I want a statement from you. This has been paid in full and no other money is needed. I only had one company, it was Bell Cell Phone, say that they were not going to accept that, which was fine because after 3 years, they didn't get anything because they filed a judgment, but after 3 years, it comes off your credit report. So I wouldn't get too anal about some of these things. If you can pay them and do the honorable thing, fine. If not, it will come off the credit report after a few years. You can handle criminal court cases for them. You can acquire a waiver for school loans, for a Pell Grant and all, but keep in mind, if you get the waiver for the school loan, until that is actually paid off, they cannot ask for another school loan should they ever want one. But if you don't do that, I found school loans will be like you might owe $2,000 this year, 4,000 next year, 6,000. Is like, whoa, when does this ever stop? So you definitely want the waiver for the school loans if you can get it. You can cancel credit card. This is supposed to be cards, not cars, but you can cancel credit cards. And there's a lot that you can do with the estate. If you don't need the estate and you're just handling the money that they're receiving, like SSI money or SSDI, you don't even need a conservatorship, but you can have representative payee. And to get that, you contact the treating doctor. They fill out a form for you to be representative payee. You give that to the public or to the Social Security. Open up a bank account in both their name and your name. It will be reported to the IRS as their income, but only you will have control of that bank account. So the money will be direct deposit in the bank account. You use the money to pay off, like if they're staying in a board and care, to pay the rent for that, to pay whatever needs they have. Okay, but if you don't need the conservatorship of the estate and the representative payee funds will work, then do that. Okay, next one. Next slide. Oh, you got it.
Okay. As the LPS conservator, your powers are limited to psychiatric treatment, placement and voluntary hospitalization and medication. If your loved one needs invasive medical treatment, you must get consent from the court. Let the court know what the issue is, and they'll give you the power to authorize those treatments. So what we often do when we have conservatees, we have ongoing medical problem up front when we're appointed or during reappointment. We ask for Power 12 to always allow us to consent to certain medical procedure. And we also typically ask any other medical procedures for power for medical procedures related to whatever issue that our conservatees are having.
Next slide. Marie, can you address emergencies?
For emergencies, the doctors can use their internal protocol. Talk to the doctor. If this is an emergency, they shouldn't wait for us to go to court for blood transfusions or whatever is needed. Talk to the doctor. They know they have internal protocols that they can use to move forward for any emergent medical issues. But you also must inform the court of what's going on. Okay, next slide. So all non-emergency invasive procedures must be approved by Department 103. No experimental treatment is permitted, and request all medical issues to be approved by Department 103. During COVID, it's been a challenge, but we work with the Public Defender's Office, especially for vaccines and treatment, so that we were getting in court in and out very quickly. So again, for anything that you know that you may need, ask for it up front when you're appointed. Next slide.
The conservatorship of the estate, and this was supposed to be up with the other one, but we kind of messed up on that. You can handle, we pretty much went over, you can handle court cases, pay and negotiate debts, request student loans be discharged, and ask the court to appoint you. When you're in court and you're getting conservatorship of the estate, and even of the person, if you think you're going to need help, ask the court to appoint you an attorney, so that should you have questions, you have a go-to person that you can contact right away. And that's very valuable. Now, if the person has money, a lot of money, then the court may require that they pay for the attorney whenever you use the attorney. But most of our people don't have money, and it's not what money you have, it's the money they have. So ask the court to appoint you an attorney should you have any questions, concern, or something should come up. Next slide.
Right.
Marie?
Marie, you unmute yourself.
Sorry about that, I was on mute.
It's okay.
For direct contact with treating doctor, this is based on WIC code 5328.1. You have the right for prognosis, medication, side effect of any medication. You have the right to have direct contact with a treating doctor. If a doctor refuses to speak to you, contact Dr. Amanda Ruiz. Here's her numbers, and you can speak to her, especially if you're having issues at a county hospital. Call DMH because we have to pull at county hospitals. For private hospital, when private conservators call me, I always tell them find the chief of staff and speak directly to them if you're having issues with a nurse, doctor, or just reaching anyone that's affiliated with your loved one's care. There's always somebody at the top that you can reach and speak with. Next slide.
Criminal court cases. If your loved one has a criminal court case, you can request Department of Mental Health court linkage program. That's the phone number for it, so that they will be involved in the case. If when they're in the court, actually you can request for a jail diversion or to have the program so that they can get into some sort of a misdemeanor or a program for jail diversions. And usually those are about 18 months to maybe 2 years. What will happen is, generally speaking, at the end of that time, if they have been compliant and been able to follow through, the case may be totally dismissed. So that's something to really try to get the person under if you can, and you'll do that through that court linkage program. Criminal court, by the way, when you're placing a person, like if they're in jail and you're placing them into a treatment facility, the criminal court has the first right for placement to say whether they can go there or not. Normally, you would have the right to say where the person goes, but if it's going through criminal court, they have that power first. But they will listen to what you say. If you say, I'm going to take them home, you can forget that. That's just not going to happen. But they work with the courts, with the public defender. They're very knowledgeable. They've been pretty well educated. Generally speaking, you shouldn't have to hire an attorney unless it's a very unusual case. Okay, next slide.
Yeah, I must add, if your loved one is ever arrested or in jail, let them know that they are LPS conserved, and they should be on the jail side or the mental health side of the jail or wherever they are. Let them know they're LPS conserved. That's going to make a big difference in the case.
Right, and in the court, let them know in the court that they are LPS conserved. All right, next slide. Possible treatment programs. Generally speaking, in Los Angeles, we have the LPS conservatorship, which is the one that can mandate medications. And the medications are what will help your person with reasoning ability, clarity of thinking, but be sure it is the right medication. There are a lot of medication. What works for one doesn't necessarily work for another. So you want your loved one to be on the medication that gives them the best clarity of thinking with the least side effects. Assisted outpatient treatment is in Los Angeles is a really good program because Linda Boyd is at the helm, and she does a great job trying to keep people on track, educating them and making sure things happen. And if there's a problem, she'll jump into it and take care of it right away. AOT cannot mandate medication. The judge can say, we want you to take this medicine, this is what we're going to do. But if the person does not take it, they really don't have any legal leg to stand on. But what they will do then is start pushing for the LPS conservatorship, which is very helpful. They'll even go to court and testify and tell the judge, we've tried, we've done what we can. I believe LPS is the best way to go. The full service partnership, if your loved one has good reasoning ability, the full service program is helpful because it's people that will come directly to them, to your house, to wherever they are, and they will talk with them, work with them, encourage them. And if they can get them on board, you're going to have a pretty successful situation. Those are pretty much the three basic treatment programs that we have right now. They're talking about a care program, but it has not been signed into law. They're still working out details to see if it's going to work. But right now, these are the three main things that you can use to help your loved one. Next slide. Medications. Know all your medications. Look it up. And Jim's got a website that he can tell you about where to go to look at medications. You want to know the side effects, but keep in mind, even aspirin, one of the side effects of aspirin is death. So take it all with a grain of salt, but be aware of it. The dosages, the high and low dosage. Know when your loved one's taking these. Is it morning? Is it night? And what dosage do they have? Keep that in your journal and notice their behaviors. You definitely want to log all that. Research all medications. Now, something you can do, you can contact the pharmaceutical company that makes these medications, and you can discuss with them directly your concerns, what you're seeing, what you're not seeing. They are very, very helpful. Your goal is to find the best medication for clarity of mind with the least side effects. And when I say do not settle, do not settle. I've seen people who just sleep all day. Well, they're doing better. Who wants to sleep their life away? I think I'd rather be psychotic than sleep my life away. You want to be sure to find what medication works for it. Now, this is my opinion. I believe you have those who have mental health problems and those who have serious mental illness. Medications is like taking a Tylenol, giving Tylenol to a person who has a migraine. It isn't going to phase them. And that's my opinion about certain medications. Depakote, Seroquel. Seroquel helps you sleep. Zyprexa puts the weight on you, but it really doesn't. I've seen only one person out of 20 years who got really clarity of thinking. They just really don't. There are a lot of other medications that don't do as well. Some of the medications that help those with serious mental illness, I tend to like Invega, and I'm giving you the feedback that I get. I'm estimating about 85% of the people have good success with Invega, but some people it's terrible. So each medication is an individual thing. You have to keep those notes, what you are observing. I like Invega because within 3 or 4 days, you're going to know if it works. And they do have the shot, which is very helpful if somebody's non-compliant with treatment. Now, just something to put in the back of your mind. If your loved one is going on the injectable, the shot, generally speaking, all medications will say, okay, every 4 weeks. Your loved one may metabolize the medication much faster. So if after 3.5 weeks, you see that they start becoming agitated, then they probably need to have it every 3.5 weeks. But likewise, if 4 weeks come and they're still doing all great and everything, you might be able to push that out to 4 weeks, 1 day, then 2 days, then 3 days. You just have to judge it by yourself. And that's where your notes are going to be very helpful. Invega, I tend to like that. A newer one is Vraylar. V is in Victor, Raylar. Now, I've only had, it's kind of new, I've only had about 8 people that I know of that are on it. 8 of them or 7 of them have said it's a miracle drug. The 8th one, it was disaster. So keep in mind, your neighbor might have their kid on a particular medicine and it's doing wonderful. You go, oh, I want to try it. And you tell the doctor, I want to try this because it's working for my neighbor's kid. He's not going to do that. He's not treating your neighbor's kid. So, and you might put them on the same medication and it may not work. There are cases where you have to know what medications, when you read about the medications, it might say, do not give with. And the pharmacist can help you with that also. They're pretty good. Okay, Jim, you want to add to this?
Not a whole lot. There is a app that you mentioned, Gail, and that's drugs.com. It's available as an app. It's also available so you can have it on your cell phone, or you can just go to drugs.com on your computer. It lists every medication known to mankind, I would say. You can look up medications by name or by type. It will tell you what is a normal range of dosage. So if you had a concern about a medication, you thought the doctor had too high of a dosage, you could look it up and compare that to what the manufacturer is recommending. I like to actually set up a graphic chart in my computer, and I will list all the medications and when they started or when they were stopped. And then it allows me to actually take notes and then close the notes out so that, within a given cell or something like that. Or if you just write it down by hand, you want to write these medications down, what range of dates your family member has been using these, and if they stopped and why, are they working well. It just really helps to keep a journal. As the years tick along, especially if you're kind of new at the game, you'll look back 10 years ago and the doctor says, what medications have your loved one been on? And you think, well, let me think a minute. Gosh, I'm not sure. So keep a journal. You'll have that. You'll know which ones have worked well and which ones don't seem to work very well. And that's all I have to add to that.
Okay, I'd like to add one more thing. When you're working with the medications, unfortunately, there are many doctors that graduated at the lower half of their class. And we've had things where the psychiatrist told the family member, all medications are the same. It doesn't matter what they're on. And he had this person on a medication that just wasn't working. And the family was trying to get him to try something different. That was his comment. He says, you just need to find another doctor. Well, they did. They put him on a different medication, and that person's been working for like 15, 20 years now, doing very well. So the other ones, if they'll try to give a smorgasbord of medications. Silver Lake had a fellow that was on 13 psychotropic medications. I had no idea there were even 13 psychotropic medications. Called the CEO, who I knew at the time, who was there at the time. He looked into it, and boy, that was taken care of right away. Every medication comes with side effects. So the more medications you have, the more side effects. And if you're having a smorgasbord, you're all over the place. You want to find out what medication works the best. Medications is a key towards your loved one getting well. And if the psychiatrist prescribes 3 psychotropic medications, you want to tell me which one's working? Because you have no idea. It's the old scientific method, change one variable at a time, and note on that. So this is the power that you have to approve or disapprove medications. You're not prescribing, you're just approving or disapproving. It's the doctor who's prescribing. But if you get a quack doctor, get another doctor. And if you've got a good doctor, you've just hit the jackpot. Next slide. Using that scientific method, change one variable at a time, find the medication that works the best, and then add if you have to after that. Keep your journal. Jim?
I have nothing further to add to this one.
Okay, next.
We covered it.
Next slide. Oh, the formulary for medications. Okay. If medications are not listed on your insurance profile, you can request that the doctor writes a formulary to request a new medication if there's one that you feel will work. The formulary is not a big deal. It's 1 page, but the doctors will act like it's, oh my gosh, that's going to be a big effort. They just write in there, we've tried this, and this, we're trying that. Doctors tend to get free samples from the pharmaceutical companies. And if they don't, you can call the pharmaceutical company and ask them to deliver free samples to that doctor. And then your loved one can try it rather than going through the formulary and getting Medi-Cal and Medicare to approve it. But Medi-Cal and Medicare pretty much approve a lot of these medications. You want the medications that help serious mental illness. And again, I cannot stress, do not settle for just okay. You want your loved one back. I have people, their loved ones been on the LPS for a year, and they're hallucinating. They're doing this, they're doing that. And the people call and they're telling me this. My first question is, what medication are they on? Well, I don't know. That is your responsibility to know. So you definitely want to know, because if they're still hallucinating and having weird thoughts, that medication is not working. Work to find something else. Now, I'm going to add one more thing. If a person is clinically depressed, not bipolar, clinically depressed, transcranial magnetic stimulation is right now seeming to be very successful at helping them to get out of that depression. So if they are that, you might want to do the research and investigate transcranial magnetic stimulation. All it does is stimulate nerve endings in the brain to get them to activate, not to be so apathetic, but to start exercising and make the person a bit happier. Okay, Jim?
No, nothing to add. It's pretty straightforward.
Ooh, we're moving right along here. Next.
Yeah. Marie?
Marie?
So placing your loved one in a treatment facility. ICD, Intensive Care Division, is a department within DMH, and we call them the gatekeepers, meaning they're the ones who, when an acute hospital, an IMD, or any higher level locked facility is ready to place your loved one at a lower level, they will evaluate your loved one, decide which facility would be a best fit, and they would send out these packets, meaning medical records, description of the patient, to various facilities, and the facilities will come and interview your loved one. As the conservator, if you're able to, tour every facility and ask questions. As a conservator by law, your request for placement at a facility must be honored as best as possible. Having said that, be also aware that a bed like at an IMD is very hard to come by. We have patients who are at acute hospitals who may wait up to 6 months, sometimes a year, just to find a bed at an IMD. So, I know a lot of time you want your loved one at the best possible facility, but just keep in mind that an IMD bed is very hard to come by. Once your loved one is admitted or is anywhere at any facility, write on every contract your express written permission must be given for any change in medication, treatment, and placement. That means they must contact you, the conservator, for any changes in the treatment plan.
Yeah, I'd just like to add that last part is extremely impressive, because when you go to the IMD, you're the conservator, you have to sign papers for your loved one to be there and for them to treat them. What they do, they take, when you sign that paper saying, yes, you can treat them, as far as they're concerned, you have just signed over your conservatorship to them. Legally, you didn't, but that's how they're going to do it. And they may not contact you for anything. So they've changed medicines. You can't understand why your loved one is not behaving well, something's going on, or they won't even let you know that they're not taking the medication. They stopped taking it. So that statement on there, and if they say, oh, you can't put that on the contract, yes, you can. Your contract is between the facility and you as the conservator. So you want to know if there's any change in medicine, if the person's going off their medicine or you're changing their medicine, they need your expressed permission, your written express permission, and you've got it now on your contract. Like Jim said, sending your loved one to another treatment facility, sometimes they will do that. You don't want that to happen. You have to be on your toes and really know what's going on with these facilities. Some of them are very good. And I'm going to go back to the questions. When you go to tour these facilities, make a list of questions beforehand. How often do you contact parents? Is there or the conservator? Do you have a team where we go and the whole team gets together to discuss the patient, including the patient should be in that too. A variety of questions. Sex, you want to ask about what is their policy about sex, because you sure don't want to come out with a lawsuit because your son has gotten a girl pregnant. You really don't want that. And you don't want your daughter they're pregnant. It does.
Yeah.
So ask those questions. Cell phones, computers, what can they have, what can't they have? And can you take them out for lunch as they get better? Now, when the person is in the hospital, you're going to try and get their medicine as best they can so they get clarity of thinking. When they're in the hospital, if the doctors work to find a good medication for them, they can skip an IMD and go to like a step down or a board and care or something like that. They may not have to remain in the hospital for a whole year. If they're in that hospital for the whole year, I'm concerned because the doctor has not worked to find a medication that's working best for them. Okay, next.
No, I want to add one more thing.
Oh, yes.
Poor Marie, she can't have a slide all to herself.
That's okay.
On the last paragraph down here, right on every contract, your express written permission. What I am seeing, and I talked to Connie Drexler months back in Los Angeles, they are also seeing so many of these hospitals transport people not only to a different facility, but oftentimes at facilities out of county. And in fact, so often it goes out to San Bernardino. And according to Connie Drexler, the Welfare Institution Code has a clause in it that states that a 5350 can, for conservatorship can only be written if the county board of supervisors sign off on that. And so evidently the county board of supervisors in San Bernardino signed off on a 5250, but not the 5350. Therefore, I've actually had families that tried to initiate a conservatorship, and their loved one was transferred out to a hospital in San Bernardino, and they lost that opportunity to get the conservatorship. And as well, they don't keep them out there long enough. So this last paragraph about your express written permission, I think is a real game changer, and I have not really paid that much attention to this in the past, but I think that should be written on every contract that you sign when they ask for your permission to treat. I think that's imperative. I just can't stress that enough.
Also, ask them to, I'm sorry. Also, you should ask the facility to write in on their chart or their face sheet that there's a conservator and this is their contact information, and to contact them with any change. That's how we do it at PG. We put our cards, we write it in, whatever they need to know, this person is conserved and you need to contact us. We like to put it on the face sheet itself.
Oh, okay.
Good.
Face sheet, you mean like the very first page?
The very first cover page in the chart. And every facility has a chart.
You can even write it in red. It gets their attention.
Great. Take a red pen.
Okay, next slide. Marie?
So again, when it's time to transfer, the hospital will make a call ICD, which in DMH, and they will make the referral to different facilities to come evaluate your loved one and to find the best placement. A person can only be transferred from a lockdown facility to another lockdown facility. Institute for Mental Disease, IMD, is a lockdown facility where the hospital will first discharge the patient. As patients improve, they may skip the IMD and be discharged to an enhanced residential housing, which is a secure treatment facility. We call them ERSs as well, which is like a very structured facility before you go to boarding care, where there's a treatment staff, medication management, and it's secure.
Okay, I'd like to add that when they're in the hospital, and the hospital should request the intensive care division to do the evaluation for where your loved one goes, you can, if you are the conservator, you can contact ICD, ask who's doing the evaluation, give them a copy of your conservatorship, because without that, they can't talk to you. Now, this is just something that I'm sharing with you that I found works a little bit. If the ICD says, okay, they usually give you 3 IMDs to go and visit. You kind of select the one you like. If you don't like any of them, for whatever reason, have a good reason why you don't.
Right.
And none of them are great, so don't expect the Taj Mahal. That just isn't going to happen. But they'll give you 3 more to go look at. When you've picked out the one that you like, and they'll try to accommodate you, but if it's not going to be available for another 6 months, and another one is now, they will have to send them to the other one. But when you go there, what you want to do is start talking to the people at the IMD. Where is your loved one on the list? And become a pain in the butt. Call the IMD about every maybe 8 days. Where are they on that list? And call the ICD and ask them where they are on the list. Sometimes you'll have two different numbers, but that's okay. If you keep doing that and you show interest and you're excited about it, chances are they're going to say, oh no, we have to go in order. But let me tell you, sometimes they move somebody up above. In fact, a lot of times they do. So that's a good way to kind of move the process a little bit faster. And you did not hear that from me. Okay, next slide.
Treatment and placement via jail. Generally, it will be in the state. Generally speaking, if your loved one's in jail, they'll be placed at a state hospital, typically Patton or Metro. But for the last couple of years at the Public Guardian, I don't know if this is the same for private conservators. The state hospitals, it's been really, really hard to do placement straight from jail. So our clients, we're finding that they're sometimes going to IMDs, and we have a new facility that just went online the last couple of years, CPT. I believe it stands for California Psychiatric Treatment Center, but it's in Delhi, California. So that might be problematic for, for visit. That's what, it's almost 400 miles away, but that's one of the facilities that has been accepting our conservatives straight out of jail.
It's good to know.
Yeah, it's called CPT, California Psychiatric Treatment Center in Delhi. I never knew there was a Delhi.
Okay.
Okay, I'll take the normal movement through treatment facilities. Okay. An IMD, Institute for Mental Disease, also known is also known as a lockdown facility. Basically, the enhanced residential housing secure facility and board and care is the least restrictive. So when somebody's being transferred, you can't go from a less restrictive environment to a more restrictive environment, such as a board and care. You can't move somebody from a board and care up to an IMD or an enhanced residential housing setting. You can go sideways. You can go from an enhanced residential setting sideways to another setting that's equal to that or less, but you can't go up. Is the key point. Conservative may skip a facility and go to a less restrictive facility as they improve their recovery. So your conservative is doing well and so forth. You can actually skip, let's say, the enhanced residential housing facility and go directly to a board and care, which is the least restrictive. Next slide.
Doctor can request for the court to remove you as a conservator. At the Public Guardian, one of the most typical calls we receive from facilities are, especially the treatment team, they're having issues with the conservators. When they want to get them removed, is usually because the conservator is not agreeing for medication, or they're not able to reach the conservator, or the last few years, a lot of conservators are wanting to try marijuana as a treatment, and that's a big no-no. So, I'm sorry, am I on the wrong slide?
No, you're doing fine. Go ahead.
Oh, okay. So as a
Maybe
conservator,
one,
yeah, you guys are one behind, but that's okay. So as a conservator, you must be reasonable. If not, the treatment team will contact the court or the Public Guardian and request that a successor be appointed. On the other hand, if you're having issues with the doctor or the treatment team, you may request for a change of doctor or a change of treatment team. Next slide.
You just did that one. You want to do the next slide? Thank you. Okay. The conservative's loss of rights. When a person is conserved, they temporarily lose the right to drive a car, enter contracts, and determine where they live. The more permanent restrictions are they lose the right to shoot and possess a gun. And Marie, correct me if I'm wrong, but I believe that's federal. And I think
Correct.
it's good 5 years on that.
Mhm.
They do take away their right to refuse medication, and that you do not get back. But while they're under a conservatorship, they can get the right to drive a car, they can get the right back to enter contracts and to determine where they live, because it is the least restrictive. You don't want a person being locked up in an IMD forever, only till they are getting better and they have more better reasoning ability. Then you can move them to a lower facility, but they can end up, person could be under conservatorship, drive a car, work, have contracts, write contracts, and live in an apartment. And sometimes some conservatees choose to stay under the conservatorship, although it's hard to get the doctor to write that they're gravely disabled because they're supposed to be that. But they choose to be it because it's a fallback. If they start to decompensate, the conservator can get them back in treatment, really fast under that 5358.5. So if they're working hard, they've accomplished a lot in a company or in a job, and they start to slip, they're not going to have to wait and decompensate to harm to self and harm to others. They can get them back into treatment right away. That's why a lot of conservators, not a lot, but a number, choose to remain under the conservatorship. In the state of California, to my understanding at this point, they do not have a medical directive for people with serious mental illness. You have it for everything else, but not for a person with a serious mental illness, which is unfortunate. They should. Anybody want to add to this? Okay, next slide. To reinstate the rights of the conservatee, if you're going to get the right to drive a car, first of all,
Gail, I'm sorry.
Yes.
Gail, I meant to add to the previous slide
Sure.
concerning guns and firearms.
Mm-hmm.
If your loved one owns or possesses a gun and the ATF, finds, well, they will know that they're conserved. They will ask for the gun back. We've had that
Right.
happen at the Public Guardian, where we've had conservatees who's had gun, and they come to us asking the whereabouts of the gun. So know where and if your loved ones have guns.
Okay. Now, do they give them back after like 5 years?
That we don't